the crucial thing is to give a separate independent head of withholding assent and keeping it with himself. Remember, Malas, withholding assent means neither rejecting nor assenting, doing nothing. Will Malas overturn on its head the entire constitutional scheme? That's the most important argument. Your lordship is then making it a super legislature, a super CM, as far as the governor is concerned. It is contrary to the entire scheme of the constitution we are arguing for the last so many days. In effect, a withholding assent option is an option simply to keep it in limbo, indefinitely, no time period, permanently, semi-permanently. It kills the bill. The governor kills the bill. A killing of the bill is available only to the cabinet government. Nobody else.
Legislature.
Which is cabinet form of government, of which the legislature is the main part, but the cabinet is a subset of it. Cabinet is a subset of it. Correct? It can't be a power of killing a bill. The governor, your lordship will have no scheme of the act left, of the constitution left. And lastly, Malas, I'm just picking up on a sentence which fell from my Lord Justice Narasimha. It is not very vital to my argument, but it's just making a last point independently on this, which I end this. Malas, there is no other procedure known in the constitution of this falling through. The only thing known is this procedure in 200 and a separate procedure of lapse in 196. Unless a bill lapses, there is no falling through of a bill. There is no third, fourth, fifth category called falling through. Lapsing is 196. It's a separate defined procedure. It will lapse when it will dissolve. It will not lapse when it will dissolve. It will lapse when it will prorog, etc., etc. We're not concerned with that.
Falling through is an expression of a court, not an expression of a
That's my case.
even interpret it on the basis
No,
of either Banduri or
my learned friend's entire argument is based on those 4 lines. Well, that's my argument. Great respect.
taking two extremes.
Very well. Now, Malas, I leave that and come to just ending this part at page 61, just 2 lines. There is obviously no fifth option, which I learned, that's my para 39. Page 61, para 39. I have given 6-7 reasons for this falling through point. I've left it now, Malas. 37. In respect of Articles 200/201, neither the governor nor the president involved.
Para?
47, Malas,
47.
at page 63, small page.
Yes.
Some of these are answering, Malas, Mr. Mehta's submission. Now, he used the word high prerogative. It's not my word. In respect of so-and-so, neither the governor nor the president enjoy any general high prerogative or plenary power which is immune from judicial review or justiciability. Why? In a constitutional republic governed by rule of law, judicial review and the supremacy of the constitution, not the judiciary, the very concept propounded by the government in this regard is fundamentally erroneous. This is expanded in paras 55 to 64. Judicial review has been repeatedly held to be part of the basic structure of the constitution, is exercised in diverse and multifarious situations, ouster clauses of different sizes and colors, no-go areas of different use, statutory and constitutional bars of differing width and amplitude have repeatedly been rejected by constitutional courts as a legitimate ouster of judicial review. Many diverse examples my lord has. In every area. Where he has discretion. Here, in most cases, he has no discretion, but where he has discretion, judicial review is never ousted or even was in any manner controlled. Basic structure. That's 65 to 78. Actions in violation of explicit constitutional text or in breach of clear constitutional intent of the founders or at variance with the context of a constitutional provision or its rationale cannot be immunized from judicial review by recourse to the doctrine of political questions, which is wholly, my learned friend used the phrase, this is not my word again, high prerogative and political question in Mr. Mehta's phrase, which I am answering in para 79 to 85. Withholding of assent and thereby supposedly making the bill fall through has no connection with and is wholly unrelated to the alleged bar of quia timid actions wrongfully applied through the fallacious invocation of Quixote. One argument my learned friend is that Quixote prevents quia timid injunctions. And a falling through means that your lordship will be interfering at the interim stage, and that is barred by Quixote. With greatest humility, it's the most convoluted argument. It has no application to the case. None. 51. Protective provisions providing an arc of protection for several diverse public servants, even in ordinary statutes. Forget 361 minutes. And similarly to high personages like the President or the Governor in articles like 361, in respect of any act done or purporting to be done by them in the exercise of their powers and duties, have never been interpreted or applied to oust judicial review and justify arguments of lack of justiciability qua the actions and decisions of such persons. They are a well-established old paradigm for provision of a protective umbrella against personal, civil and criminal actions in respect of work done by holding their office. So, if I take a decision, your Lordship quashes the decision right, left and center. But that doesn't mean that your Lordship quashes, then I file a second action for tortious liability against the Governor. 361 is that. And it's a well-known common law exception from 300 years in England, which has become 361. Judicial review, again, nothing to do with judicial review. Because judicial review hits the decision of the action. 361 bars the personal immunity from civil, tort, contract. It will be totally irrelevant to the case. I'll cite the cases coming in. The provision in US is on 361 is much narrower. But barring the last step has been interpreted by US Supreme Court to mean the US President can grant pardons to anyone, and now supposedly to himself also. Now supposedly to himself also. That last part is not decided, but it is likely that it is so going to be held. Anyway, let's go on. The fundamental fallacy of the Union of India's averments on the alleged non-justiciability of a governor's president's actions under 200-201 is that they proceed on the flawed assumption that the governor exercises high prerogative and plenary power. This is Mr. Mehta's submission in 281. Wrong. Completely decided cases say it is wrong. And then discretionary powers I've already said. Now let's go to 47. The first para was 47. I'm elaborating it from 55. Neither the governor nor the president enjoy any high prerogative or plenary power. Immune. Well, this is found in para 55 of my note at page 281 of his submissions. Ignore it. Let's just note the reference. Ignore 56 also. Come to 57. Well, this is a slightly different but related topic I'm getting out of the way in the beginning. This is not that. Here I'm showing that governor exercises no legislative powers. It's well decided. He is part of a legislative process. He exercises no legislative powers. That's a very important distinction. The impression given to your Lordship is because he is part of a legislative process, therefore he is also exercising some legislative powers.